Good afternoon, and welcome to today's edition of Florida Appeals Journal. My name is Jennifer Carroll, and today we're going to talk about, I think, something very interesting within the ambit of the evidence rules that govern litigation, uh, the hearsay rule. And few lawyers ever get a mastery of it. I think always, even the most experienced lawyers and judges, you're always tweaking your knowledge and how to apply it to different sets of facts, circumstances, to be successful at any trial, and just to look like you have a semblance that you know what you're doing. You really have to master all the rules of evidence. But I think the most important one is hearsay, because hearsay always comes up. And hearsay, and okay, first, how do you define it? A layperson, oh, that isn't that somebody told somebody told somebody. You've got a witness who can be on the stand testifying, and then they're going to testify as to what an individual told them outside of court. And that individual outside of court is the declarant. And think about it. The courts don't think that's, good evidence, right, to support your case, because you have a right to confrontation. An individual will have a right to confrontation and to cross-examine the person who made that statement. So it's only fair, right? It's only fair that that really needs to be kept out. But it's really not that simple. When you encounter a hearsay statement or a hearsay document, something in writing, the first question you need to ask is, well, is this hearsay or the type of hearsay that's prohibited under the rules? And the first question you have to ask yourself is this offered for the truth of the matter asserted in the statement? And if it's not, it's really considered non-hearsay. So non-hearsay, and then you can go ahead and get that admitted. But there's a whole process to go through. When you're trying to explain to the judge, should this hearsay be admitted? And when I'm talking about non-hearsay, I'm talking about a different thing than exceptions, because the rule has so many exceptions to application of the hearsay doctrine. And the fine line. So it's really just practice and knowing the cases too, and knowing what the courts look at to see when exceptions are applicable. But today we're really going to focus on, do you have hearsay in the first place? So 90.803, section 90.803 is what governs the hearsay rule. And unless you've got an exception to the hearsay rule, and let's say you have true hearsay and you want to offer this statement for the truth of the matter asserted, the other side is going to object, and they say classic hearsay, and the judge will sustain that unless the proponent of that statement can show the court that an exception applies or that it is not hearsay and you're offering it for another purpose. So you would say on your objection, if someone is going to object, that's hearsay you're trying to bring in through this witness. You're going to tell the judge, well, judge, this statement is being not offered for the truth of the matter asserted. They may say, well, we're really offering it because it goes to really credibility of another witness in the case. So it's for a purpose other than what actually is being asserted in the statement. So the effect, if you're offering it for the effect on the person who heard the statement, then it's considered non-hearsay. You can offer it for purposes of showing a prior inconsistent statement. Again, not being offered for the proof of the matter asserted, so it's non-hearsay. Also, you may be offering it for an operative fact, legal fact, or a verbal act. And that has to have independent legal significance in the case. So again, you're saying, well, it's important, just the fact that a statement was made, Your Honor, and so it's non-hearsay. And then you can also argue, well, it's important for showing knowledge of the declarant. So there are a series of reasons, and I would say you've basically got the three classes of general classes of statements that fall outside the hearsay prohibition, okay, of the Florida statute. And the act of speaking certain words, if it has an independent legal effect, aside from truth or falsity of that statement, then you don't need to worry about the right of confrontation. That is going to fall under non-hearsay, and you have a chance of getting that in. Certainly, it won't be prohibited under the hearsay rule. Then the second class is you are offering it for the probative effect that it has on the listener, and that can be important. Again, you've got to apply the law to it, and it has to have that independent legal significance. And then the third class is when you have the non-hearsay statement consists of assertions by the declarant which exhibit knowledge of a fact or a condition, and that knowledge has to be material to the case and to the outcome of the case. So I'm trying to think of examples, because that's the only way really to understand a lot of this too. And one example, let's say you've got an out-of-court statement by a garage mechanic, okay? And that garage mechanic says to individual A that A's brakes were defective. The courts have said that's not hearsay if it's offered to prove that individual A had noticed that the brakes were defective. So it's a notice issue, and you're not offering it to show that, hey, in fact, the brakes were defective, but you're offering it to prove notice. And just these, if you can get these basic principles, well, not so basic, but have an understanding of these basic principles, it'll help you understand a lot of what's going on in the trial court and these objections and what the court may be thinking of also. So if you're not offering it to prove the content, but for some other independent purpose, and remember, the purpose that you are offering it for, it has to be relevant to an issue in a lawsuit. So remember that. And there's a pretty good case, McWatters v. State, 36 Southern 3rd, 613. That's a Florida Supreme Court case. And it holds that statements during an interrogation are admissible to provide context to the suspect's, in other words, the listener's response. So such a statement can be admitted to provide a context to the defendant's responses and to set forth the circumstances in which the defendant or the listener made a statement. So that's really important. That, believe it or not, comes up quite a bit, and certainly not just criminal trials, but in civil trials as well. So you can use that to really get in a lot of statements, and it's not being offered to prove the truth of the matter asserted. But again, you always have to be careful. Bench trial, jury trial, maybe it can have that same effect, but it's not supposed to. So that's one prime example to that. So those are the fundamental classes of non-hearsay. And I want to bring up, and we'll probably do this in another at another time. There are so many exceptions to the hearsay rule, but remember that the exceptions have to be adhered to strictly. So the proponent of the statement, you want to get that statement in, you have the burden to strictly comply with the requirements of the statute and with the requirements of those exceptions. And one thing to remember also is, with respect to the admission, exclusion of evidence, as most of you know, I'm sure, the trial court has considerable discretion, but oftentimes you see cases reversed because something was erroneously excluded or it was erroneously admitted. And just remember the key principle that, well, it better make a difference in the case, because there could be legal error that was committed in the trial court, but if it really didn't affect the outcome of the case, or certainly, reasonable minds can find that it really didn't affect the outcome of the case, then it's not harmful error, and therefore it's not reversible error. So keep that in mind. And you need to know the standard of review. Like I said, we know that there's discretion, generally abuse of discretion with the admission exclusion of evidence, but Whether or not something is hearsay, that is subject to de novo review, and that's something that that means as a matter of law. So the appellate court can go ahead and step into the shoes of the trial court and make a de novo determination. Well, we think that statement is hearsay, or it's non-hearsay, or it does fall under the exceptions. And a pretty good case on that, just on those standards too, is the Philip Morris case, 228 Southern 3rd, 1115, and that is, I believe that's what I thought, the fourth DCA case. That's actually 2017. But just remember, trial court's ruling on admissibility is reviewed for an abuse of discretion. And then you've got legal questions of whether evidence falls within the definition of hearsay or is admissible in evidence under one of the exceptions. Hearsay rule. That's reviewed de novo. So that's a good case for laying that out as well. So, and one other thing also, with the exceptions, one of the really most popular ones that it's popular and yet few people really understand it, and that's when we get into an analysis examination of the hearsay exceptions. At another time, we'll look at those, but they get very confusing. You know, admission of party opponent, adoptive admissions, the list goes on. But there's one. It's a state of mind exception, and sometimes that gets confused with, well, is that really non-hearsay? But if the statement is relevant to the individual's state of mind, let's say the party, plaintiff or defendant, to their state of mind, and their state of mind is a relevant issue in the case, then the state of mind exception applies. And sometimes people get confused and say, well, really, that's not hearsay. Yeah, we can certainly debate that point, but the law treats it as a state of mind issue, exception falling under an exception to the hearsay rule. So that's just in a nutshell, initiating some basic principles of hearsay. And next time we're going to try to go ahead and address more of the exceptions to it, and some of the other, I think, good principles to know when you are litigating your standard case and have a lot of evidentiary issues. So any questions, by all means, contact us, or if you want to see a topic addressed. Thank you again for watching Florida Appeals Journal today. Thank you. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.